Let's start with what happened last Friday in Fort Pierce, one of my favorite haunts. You were actually in the courtroom arguing as an amicus, as a friend of the court, on behalf of special counsel Jack Smith's position that he was properly appointed according to the appointments clause as special counsel. Kind of quickly, take our viewers through what happened in court that day.
Thanks for having me, Katie. So it was extraordinarily unusual for a court, and especially a trial court, to have amici like me to argue in a case. And so even at the Supreme Court, where there are amicus briefs in every single case, sometimes dozens or even hundreds, less than 0.25% of the times does the court permit amici to actually argue in the oral argument. But in early May, Judge Cannon asked the amici who had filed on this issue of the constitutionality of the appointment of the special counsel whether they wanted to participate in the argument. And the defendant, Trump's amici, said they did. And so we wanted to participate to give equal time to our position. It was a hearing that lasted almost 5 hours, which is a lot of time to give to an issue that has been raised in many courts across the country over the last 50 years and rejected every single time.
Matthew, let's switch gears because you're very busy, and you wrote a amicus brief. I guess you say amicus, or maybe you say amicus, tomato. So you wrote an amicus brief for the Supreme Court in Fisher. And this decision that came out yesterday from the Supreme Court on Fisher is very important because there are some doom and gloom people that think that this decision will adversely impact special counsel Jack Smith's prosecution of Donald Trump in the various election interference cases that he's facing. But you, in your brief to the Supreme Court, took a middle of the road approach, something that was not as far reaching as the government purportedly was seeking and nothing as narrow as what Fisher was seeking. So tell us why we should not have a chicken little sky is falling kind of emotional reaction to what Fisher said yesterday.
What the court did in Fisher was that it adopted, as you said, a moderate interpretation, an intermediate interpretation of this statute, section 1512C2, which makes it a crime to corruptly obstruct, influence, or impede any official proceeding. And the interpretation that it ultimately adopted was broader than what the defendant, a violent January 6th rioter, had asked for. He wanted an interpretation that limited the statute only to the destruction of evidence. And the reason he asked for that is because this statute was passed in the aftermath of the Enron scandal. And the government, by contrast, asked for an interpretation that applied to any type of obstruction at all. And the court adopted a position that I think is quite close to the position that we advocated in our brief, that takes a middle path. Now, in this case, Fisher won in the sense that the decision below is reversed, and we'll have to go back down and ask whether Fisher's violent conduct falls into this moderate interpretation of the statute. But in 6 months or a year or 2 years, we're ultimately going to find out that it does, because there's no question in my mind that the violent protesters on January 6th impeded the use of an object, namely the electoral certificates, in an official proceeding, the counting of electoral votes. And so what we see here in Fisher is part of a larger pattern where there's a little bit of a setback for the prosecution that takes a lot of time. And so ultimately, I don't think it's going to make a difference in the guilt or innocence under this statute of the violent January 6 rioters, or ultimately of Donald Trump. But it will take months or years for us to find out whether that's actually true.
And Matthew, you also filed a brief backing the special counsel Jack Smith in the criminal immunity case that ended up in front of SCOTUS. Again, incredibly busy that you are. We obviously know now, the Chief Justice announcing yesterday that Monday will be the last day that we will have opinions released. Your thoughts about this criminal immunity decision that's imminently going to be coming out for Americans to hear on Monday?
Well, it seems I'm the sunny optimist of your guests. I actually think that we're again going to see an opinion that looks good for the president. I think it's certain that the court will say that some presidential conduct is immune. You can't make it a crime, for example, to veto a bill. But outside of that, I think there's a real question about how far the court goes in establishing a presidential immunity. But even more than that, just like with Fisher, even if the court gives President Trump everything that he wants, that he's immune for every official act that he took while he was president, he's still going to be subject to a trial as long as he doesn't drop the charges against himself next year. The reason is that if you look at the indictment, the vast majority of the conduct that's alleged that he's being charged with is clearly unofficial conduct. Outside of trying to malignly influence the Department of Justice, all of the conduct was taken in his unofficial capacity as a candidate who was trying to unlawfully reverse the results of a legitimate election. So what we have here again is a situation where the ultimate outcome actually, I think, is going to land against Donald Trump. But we've now been 7 months here waiting for the Supreme Court to tell us what the rule is, when no matter what the rule is, Donald Trump is going to lose. And so the ultimate upshot of this, I think, is that we've seen in every single case that we're talking about an enormous amount of delay. These judicial epicycles where we ponder what the right rule should be, when under any rule, Donald Trump should lose. And so it's the delay that ultimately risks so much.
Matthew, very quickly before I have to let you go, I have been pushing this idea that what we will see is Judge Tanya Chutkan get the case back from SCOTUS, and she conducts an evidentiary hearing of sorts wherein she parses out what constitutes official/unofficial acts to have what remains of the indictment. I mean, that's exactly what SCOTUS was asking during the oral arguments on this issue. Do you agree that we could see something of that ilk, like an evidentiary hearing where Americans could hear the sins of Donald Trump before November?
Yes, I think that's quite likely. In fact, if the court issues a rule where the district court, Judge Chutkan, has to decide which conduct that's alleged is official and what's not, I think an evidentiary hearing is likely to happen. And that will air so much of the facts that we actually know, but many Americans have sort of dropped down the memory hole. And so this fall, for Americans to see just how grave his crimes against democracy were in the 2020 election aftermath, I think that could serve an important public purpose. Of course, it would serve a judicial purpose, but it would also inform the American public about just who they're contemplating electing again.
Matthew Seligman, I appreciate your advocacy and your legal acumen. Thank you for sharing it with me and with our viewers today. I appreciate you.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.